Over the last year, we have seen the U.S. Supreme Court take a hatchet to many of the rights we have enjoyed in this country for decades. Now, Democrats and liberals say the six conservatives on the court are compromised and slanted to appease Donald Trump's Republican Party. Conservatives say Democrats are whiny little babies who are upset because the court is righting prior wrongs decided in landmark cases like Roe v. Wade. Today we're asking who is right, and is the U.S. Supreme Court compromised, and are extremists on the court real threats to our democracy? Experts weigh in, all coming up next.
Live from Los Angeles, this is the Special Report with Areva Martin.
Justice Samuel Alito, who was the author of the majority opinion which overturned the landmark decision in Roe v. Wade, based his ruling on the assertion that the 14th Amendment protects only those rights generally recognized in 1868 when the amendment was ratified, and that the Constitution only protects those rights which are specifically enumerated in the Constitution. Legal scholars opine that this is a distorted interpretation of the law and that it is more an ideological argument to support the court's conservative views rather than a well-reasoned legal opinion. Scholars also argue that this line of reasoning endangers many other rights that have been recognized since 1868, among them being the right to contraception, same-sex marriage, and other LGBTQ plus rights. And carried to its logical conclusion, this line of reasoning could even allow states to ban interracial marriages, as some did until 1967. Also could give states the rights to attack the executive branch of government, which the court did recently when it denied the EPA the right and the authority to issue regulations needed to combat climate change. The Supreme Court used to be among the most highly respected institutions in this country, but through its recent decisions, public comments, and even conduct by some of its members, its approval ratings is at an all-time low. Now, critics say it's only one way. There's only one way to rein in this court, and that is to radically reform the court through such things as term limits, expansion of its numbers, and even impeachment of some of its members. How viable are these proposals to reform the Supreme Court, and how did we get here? How did we get to the 6-3 activists and, in some opinions, extremist Supreme Court? Here for our first discussion and our first panel to help us understand how we got here is Amy Steigerwald. She is a professor of political science at Georgia State University, and she is a leading authority on the U.S. Supreme Court. She's the author of multiple books, including Battle Over the Bench and Gendered Vulnerability, How Women Work Harder to Stay in Office. Good morning and welcome, Professor Steigerwald.
Thank you so much for having me.
Wow. So what we do know, Professor Steigerwald, is under the Trump administration, about 234 federal court judges were appointed, 174 or so were appointed to U.S. Courts of Appeals, and 3 we know were appointed to the Supreme Court. This isn't a record number. Clinton and Reagan appointed more federal court judges, but both of those presidents and Obama, they all had 2 terms, 8 years in office. Trump only had 4. And he essentially appointed the same number of judges in his 4 years as Obama appointed in his 8 years. And many people on the left, Democrats, liberals, concerned about these appointments. One, because not very many of those 234 people are minorities that reflect the growing minority population in this country. And many of them were members of the Federalist Society. So how did we get here where Trump in 4 years did what took Obama 8 years to do?
One of the things that is most important and that you pointed out really well, Areva, is that the longest term policy impact that a president can have is actually through their judicial appointments to the federal bench. Every time they put someone on, that person generally serves 20, 30, even 40 years into the future. And so all of those judges. So what happened there was actually a concerted effort, not only by President Trump, but also by Mitch McConnell while he was Senate Majority Leader, to both slow down the confirmation of nominees to the federal bench while Obama was president. One, of course, of the most glaring examples of that is when they wouldn't even allow Merrick Garland to have a confirmation hearing when he was nominated to be put on the United States Supreme Court. But they also did not move a number of nominees to the lower courts, and particularly the courts of appeals, so that by the time President Trump took office, there were quite a lot of vacancies. And that was really what Senator McConnell focused the Senate's business on. In fact, they did very little legislative action during those 4 years. What they did do, though, was confirm a very large number of nominees. Not only, as you said, was it a less diverse group of nominees than we've seen actually since before Carter, but it was also a group with one of the highest levels of not qualified ratings from the American Bar Association. And so there was really this concerted effort to put people onto the bench and also to therefore ensure that they would be able to rule in cases well into the future. They were known conservatives who wore that proudly. Also, many of them were incredibly young, and so they are likely to serve even longer than we've seen in past years.
So this concerted effort, obviously, as you just said, didn't start with Donald Trump, started long before him. Some cite to this secret memo of Justice Lewis Powell in 1971, a memo that he wrote to the Chamber of Commerce, really laying out a blueprint for how, really, some call it corporate domination of American democracy. Tell us what that memo was, and if you believe that it was the blueprint that got us to where we are in terms of having this majority conservative court. I think we may have lost Professor Steiger. Okay, there you go. I think we lost you for a moment. But explain to us what this Justice Powell's secret memo of 1971 was and what relationship it has to where we are today in terms of the number of conservative judges on federal courts throughout this country.
So there was the attempt to try to really pay attention to who particularly was being nominated to the lower courts and to give suggestions about how it is that people should be brought up, about who it is should be nominated. And we've seen that sort of continued through. If we then jump ahead to the Reagan years, and particularly Attorney General Edwin Meese, one of the things that he particularly put out was he was very clear that he wanted to appoint young conservatives to the bench. And he particularly wanted to focus not on the Supreme Court, because there's only 9 seats there. He wanted to focus on the lower courts. You have 179 justices who sit on the courts of appeals, and then over 650 judges who sit on the district courts. And they are the ones who hear 99.9% of all the cases that go to federal court. And so it became this concerted effort to really focus on that, to start vetting judges that were going to be nominated and confirmed much more heavily, and also concentrating it more in the White House than we'd seen, taking it out of the hands, for example, of home state senators, so that, in fact, there was sort of a concerted top-down effort to ensure that the types of judges that each of these presidents wanted to see made it onto the federal bench, with the idea that they would be able to serve for quite long periods of time.
What was the thinking back then? I've heard and I've read about several theories, one being Republicans recognizing that the browning of the country could mean that they would lose political power in terms of the legislative branch as well as the executive branch, and the judicial branch was one area where they could, consolidate their power, as you just described. Is that your understanding of why Republicans, in particular, starting with Powell, you said Edwin Meese, were so focused on the courts?
I would actually argue, so I think it goes part and parcel with also the decisions that were handed down during the Warren Court. So under Chief Justice Earl Warren, we really saw a remaking of a lot of the sort of previous holdings of the Supreme Court. Brown versus Board of Education, the expansion of voting rights, the expansion actually of what we call the incorporation of the rights that were in the first 10 amendments and applying them to the states through the 14th Amendment. That all happened during the Warren Court and was really sort of this judicial revolution. This is also where the argument started coming forward about judicial activism, about the idea that they were trying to remake society, remake laws in sort of their view, this unelected group of judges, as opposed to what it was that the people wanted, because of course, many of the laws that were being struck down were ones that had been passed, whether by Congress or by state legislatures. So yes, some of it had to do with the growing power, obviously, of Black and brown persons throughout the country. Later on, it had to do with the growing power of women, because of course it was through, again, right during this period of time that we saw the first cases that started to apply the 14th Amendment, equal protection to claims based on gender and sex, later sexual orientation. And so it was this sort of changing dynamics and growing power of groups that previously had been marginalized.
And tell us about the Federalist Society. We've heard a whole lot about it, particularly when we saw the nominees come forward for the Supreme Court that Donald Trump put forward. A lot of discussion about how these judges were all members of the Federalist Society and the role that it has played, as you said, working with the White House in identifying these judges who have been appointed recently under Trump.
So part and parcel during President Reagan's administration of trying to expand the judges that were getting onto the courts was also the realization that judges first go to law school. And so training for these particular theories of wanting to ensure that you would have kind of a bench of people in a pipeline that would be able to be put onto the federal courts. And so the Federalist Society was founded in the early 1980s in the law school. And the idea was to bring in speakers to try and ensure that these alternative legal theories were being promoted in the law schools and taught to lawyers. So that instead of discussing, for example, the theories that would come out of a more liberal side about a living constitution, ideas of pragmatism, and what are sort of the impacts of these decisions, this is where we saw a lot of the Federalist Society focused on the ideas of originalism, textualism, original intent, and trying to ensure that law students, that others were learning about these theories and could then apply them in their practice and hopefully on the federal bench once they had gotten the necessary experience.
So this concept of originalism, is that what Samuel Alito, would you describe his approach to the Roe v. Wade case, overturning it by referencing back to the ratification of the 14th Amendment in 1868? Is that an example of originalism where you're trying to literally interpret what the founders of the Constitution meant at the time that it was being created?
Exactly. So it's sort of a combination of what we would call originalism and original intent, because the question partly is, what do we look at? And then, right, we look at the text. But then once we look at the text, how do we interpret that text? Do we interpret it using, for example, definitions from today, understandings from today, or understandings from those who ratified it? And originalists say, we need to look at it in the context of when it was ratified. And so that is why, for example, in the Dobbs decision with abortion, Justice Alito says constantly, the word abortion is not in the Constitution. Therefore, the court couldn't have been thinking about this. Similarly, in the decision that Justice Thomas wrote in the gun case, New York Rifle, he similarly talks a lot about what were the laws in place at the time that that decision was handed down, that's the context that we need to understand these provisions and then apply them to the laws of today. And so it's very much this originalism idea, and the idea that we are not to rethink the Constitution to match what is going on today. that instead, sort of the hallmark also of originalism, which is sort of an important point, is that if you do not think that the interpretation, that this original intent matches what's happening, we should amend the Constitution. That is the answer, as opposed to justices sort of reinterpreting it based on common understanding. The concern, of course, is it's almost impossible to amend the Constitution, and it's happened very infrequently through time.
So what would be the opposite of originalism and this concept that Alito and Clarence Thomas have applied in these recent decisions?
Sort of the best term that I've heard to explain sort of the opposite is what people call a living constitution. The idea that the Constitution was a document that was written in a particular time, but was written to live into the future, that they weren't writing it just for 1789. They were also writing it for 1889, 1999, 2099. And that's part of the reason why much of the Constitution is not terribly specific. It's short. In places, it's very pithy. And it also uses broad, sweeping language. And so those who believe in living Constitution would say that that was because the idea was that the Constitution should evolve with society to be able to meet up to it. So just to give a sort of example that a lot of people probably think of, is that when the Fourth Amendment was passed and it talked about unreasonable searches and seizures, obviously we did not have all the modern technology we had today. We didn't even have right back then, there weren't even telegraphs or telephones. Well, when telephones were first put in and they had these wires that could be tapped, the court originally used an original interpretation and said, oh, well, no, what they were talking about was you're entering. You're going in, you're entering, you're physically searching. So listening to somebody's conversation, that's not a search. That's not what they were talking about. Later, the court, actually one of the Warren Court decisions, said no, right? When they were talking about searching and seizing, what they really meant was going into spaces that you as an individual wanted to keep private. It wasn't simply about that physical search. It was also there, and it was recognizing that the decisions of the court and our interpretation needed to change as society changed. As we evolved with new technology, we couldn't just hold to these original views of where it was.
So, Professor, if each individual that gets appointed to the Supreme Court comes to that court with their own core beliefs, and we're going to just simplify it, either they're an originalist or they are a living Constitution, believer, how do we ever get consistency? How do we ever get anything other than what that individual, believes? So a Clarence Thomas believes that, we got to go by this short, pithy Constitution. And we can think of a million things that are not in that little short, pithy Constitution. So therefore, under that logic and thinking, it wouldn't be protected. It wouldn't be a right that the court can protect. So if he believes that, he's going to make that kind of decision in every case. And then someone else comes along, i.e., let's say Ketanji Brown Jackson. I'm certain that she does not believe that because words like abortion aren't in the Constitution means that we have no protection for them. How do we ever get to a place where this court is anything other than just another political body and people are just deciding cases based on their own political views?
So the difficulty, of course, in asking a political scientist that is that we, of course, would argue it is a political body and it makes law. And that's, in fact, its purpose in policy, right, is to, right, every time it makes a decision and it's determining what a law means, it's making policy, it's making law, and that's, in fact, its job. More broadly, though, there's two things, I think. Number one, stare decisis, right? Theoretically, though, as we've seen with the court recently, that's not necessarily a thing. The idea is supposed to be because we want consistency, because we do not want it to be that every year what our understanding of the Constitution is can change dramatically depending on who's on the court, is that the court is supposed to look at how it's ruled previously. And in many ways...
Even that, whoever decided the first case that we're now going to use as precedent decided that first case based on, again, these two boxes that we are using for our hypothetical. So whoever decided Plessy had a mindset of either being an originalist or being a person that, believed in a living Constitution. So if we continue to rely on that as precedent or stare decisis, we are still buying into whatever that original person's political ideology was. So relying on it as precedent doesn't necessarily make it right.
No, it doesn't. You are entirely correct, right? And so that's sort of the other issue that comes in because, yes, this is in fact the fundamental struggle. There are some cases where, right, this is why we see unanimity on the court, because that's kind of the flip side of this, right? Why in some cases do we actually see a unanimous decision? And one argument is that there are certain cases where the law is simply so clear that there's no other answer that can be given. So everybody who reads it, it doesn't really even matter what type of interpretation you utilize, you're going to arrive at the same answer. Because it could be, right, that as you read something, that you arrive at the same answer regardless of which version you're using. And so there are those issues.
Professor, let me just say, let's talk about the Second Amendment and guns, because that's one of those amendments that again, we hear over and over again about the rights to bear arms. But the living Constitution people say, well, wait a minute, the guns at the time of the Second Amendment were muskets, and there were militia who had a specific purpose in terms of protecting the country, almost serving as an extension of the army. And we also know that a lot of the militia were there to fight against African Americans who perhaps were, trying to free themselves from slavery. But none of that is the reality when we look at the 22-year-old with the semi-automatic rifle shooting into a parade. So I don't know, I guess, if it's so clear that there are cases like that, even when there is language in the Constitution or the amendments like the Second Amendment.
Constitutional cases are the hardest on this, right? We see it a lot more on statutory cases. You're totally right. And so this becomes the issue, is that there also is this box of cases where, yes, the two boxes that you put the two groups in come to completely polar opposite decisions. And it really lays bare the idea that there is some sort of law handed down from on high that everyone just agrees on. No, these are in fact policy issues. These are about interpretation. These are about their understanding. And it does create this tension that this is why we see, right, the court's decisions in places changing over time. And one of the reasons in some ways why we are seeing such a radical shift in the court's jurisprudence right now is because of how quickly the composition of the court has changed.
Right.
One of the things we've seen through time is that generally speaking, the court changed sort of slowly. Each incoming president got a number of nominees, and we would sort of see these incremental shifts. There have been some periods, though, where either because, for example, with Franklin Delano Roosevelt, he served for so long, he got to appoint so many justices, or as happened here during President Trump's administration, that he served a short period of time, but there happened to be a number of deaths on the court. And so all of a sudden, he had the opportunity to really remake it in fundamental ways. And it lays bare to some degree, right, those quick shifts in composition, exactly the issue that you're bringing up. We normally don't see it because we don't see these shifts in composition happening so quickly and with a number of cases sort of ready for those justices to jump in. The final part is that it has to have justices willing in many ways to take those steps. So, for example, right, I don't know exactly what's in Chief Justice Roberts' heart, but my bet is that he's not really a strong supporter of Roe v. Wade. That said, he's an incrementalist. So that's why his concurrence was, let's get rid of viability, but we don't need to overturn Roe v. Wade. We don't need to go that far. And we've seen him counsel that type of thing. However, there's 5 justices on the court, and really it's in many ways not the Roberts court anymore. It's really the Thomas court or the Alito court who said, no, we don't need to follow precedent.
Roberts did vote with them, even though he wrote that concurrence, right?
He did. Well, he voted for the same outcome, which was to hold up the law, but he didn't vote for overturning Roe v. Wade.
Yeah, I want to bring into the discussion now another political scientist at the University of Albany, SUNY. She is the author of multiple books, including The Supreme Court and the Presidency. It's Professor Julie Novkoff. Good morning, Professor. You've been listening to this conversation, and One of the things I think that disturbs so many people is we saw those justices, those recent Trump appointees, say that they respected stare decisis and precedent, and then they voted just the opposite. So does that mean precedent, for all practical purposes, has no relevance in our current jurisprudence?
Well, I want to thank Amy for her insights, and I want to emphasize that as a political scientist as well, I want to underline the political nature of the court. It's not new that the court is a political institution, but the nature of politics in which the court is engaging right now has definitely changed. And to me, it seems that on both sides, there was a little bit of willful ignorance during the nomination hearings for the three justices appointed by President Trump. I don't think that most court scholars believed that they were going to agree with continuing Roe as a precedent. But the Republicans in the Senate who voted to confirm them were willing to accept the fig leaves that they offered.
Yeah. So you hear now, Professor, cries from some on the left to impeach two of those justices, in particular, Gorsuch and Kavanaugh, and their allegations that they actually lied to the senators on that confirmation hearing. Tell us, is that even possible, and what impeachment would look like?
Well, it is certainly constitutionally possible. I think it would be a very difficult hill to climb politically. Throughout American history, there's been a fairly strong norm against impeaching justices for basically anything that's perceived as being political. There was an attempt to remove Justice Chase far back at the beginning of the court's history that failed. And then that kind of set this norm that, no, we don't remove justices because we don't agree with the direction that they're driving the country. The question here, of course, though, is, well, if we can show that they lied in their confirmation hearings, does that put us into a different place? But again, impeachment requires a majority. Removal requires a supermajority, and that is extremely difficult to achieve. The only judges who have ever been removed have been removed basically for committing crimes.
Okay, so the country doesn't have a stomach to go through impeachment as it relates to judges, but Professor Steigerwald, what about this conduct? We have seen in this era judges on the court talking, giving speeches, appearing at public events, and talking in ways that we didn't see historically judges being. Many people didn't even know who the Supreme Court justices were. We rarely heard from them unless you were a court watcher and had some particular interest in the court. That's changed to a great degree. And there's a recent article out. We know about Clarence Thomas's wife and the active role that she played in the January 6th insurrection. And even an article that says that Clarence Thomas himself made comments to his law clerks 2 years after he was confirmed, stating that liberals had made his life miserable for 43 years. And he was hell-bent on making the lives of liberals miserable for the next 43 years, that he was going to stay on the court until 2034. And some people believe that's exactly what he's doing, that he has some personal vendetta dating back to, maybe the confirmation hearings where he was accused of sexual harassment by Professor Anita Hill, that he called that a public lynching, and he's always been angry about the way he was treated. So if in fact he did make that statement, would that be grounds for impeaching a justice who has this personal vendetta out against, the majority of the country?
So the issue, as Julie laid out really nicely, is that impeachment is actually not that difficult. It's removal. And number one, impeachment with judges happens very infrequently. Removal almost never happens. What is more likely that we are possibly going to see, but I obviously don't have any control over this, but what I would not be surprised about is that there are technically not judicial conduct and judicial ethics rules that govern the Supreme Court. They do govern the other levels of the federal judiciary, and in many ways are quite strong, especially about conflicts of interest, when they should be recused, types of outside activities that they can do. And there's a lot of pressure right now on the court, given everything that's happening, and particularly the falling legitimacy and public support for the court, to really apply those rules to the Supreme Court. That would be a really big step. Hopefully, I think it would be good if it did, in fact, happen, because it is one way to try and at least show that if there's, in fact, a clear conflict of interest, that they're not also ruling in that case.
But who has the authority to create these rules and then to implement them?
The Supreme Court.
So they'd have to decide unanimously amongst themselves that they want to govern themselves. And then they
Correct.
would be the governing body of themselves?
Yes.
Okay. So
Well, they could hand it over to an independent body to investigate and enforce, which I believe is the way that it works for the lower federal courts. I actually don't think it's impossible that something like this could happen, given that the Chief Justice has shown repeatedly that he cares a lot about the institutional status of the court. And if some fairly loose set of regulations were to be put into place, it might help him to feel like he's shoring up the legitimacy of the institution.
I'm just curious from a historical standpoint, Professor Steigerwald, how is it that the court, and maybe it was meant that this impeachment process that you just described that is very difficult, but I'm just curious as to how the founders created this branch of government, the judicial branch, with so very little oversight. I mean, was the thinking that they were infallible or they were somehow going to be above the law? Because we know we've watched Congress people be impeached. We've watched Congress people be indicted. I mean, we've seen consequences for the actions of congressional leaders. We've seen some attempted consequences even for Donald Trump with respect to 2 impeachment hearings that were held for him. But this notion that judges would now in 2022 have to get together, Supreme Court judges, and agree to create some kind of panel to monitor or oversee their behavior seems so woefully inadequate and should have been considered by these people who we say were so brilliant and enlightened, who created these these documents that form the country.
So there was a debate about this. Actually, the Federalist Papers and then the Anti-Federalists, this was one of the main areas of contention, was actually the Supreme Court and the idea that once the judges were on the court, they had life tenure. And what was going to happen there? What did that mean? The arguments of the Federalists, which in the end won out, were that because the court lacked the power of the purse and lacked the power of the sword and were dependent upon the other branches to act, that would inherently constrain its power because they couldn't actually enforce anything they did. And that has been something that has been an issue, right? In many ways, there is always the question of what are we going to do? The Supreme Court hands down a decision. Do we listen? What makes us listen? Right? After Brown versus Board of Education, the way that the University of Alabama became segregated is that, of course, right, the president nationalized or the Alabama Guard and right, literally pushed the governor out of the way to let them get into the thing. And so they needed to bring in that outside portion of government to be able to enforce the ruling. And so the idea was originally that would prevent the court from being able to go too far because it had to be dependent upon these elected branches. Now, it doesn't always work, and we've now hit sort of a point where we don't really have sort of those discussions. And some of the checks that did exist have really gotten us farther away because part of the problem is, right, it's not simply that impeachment is difficult, but also that we now have sort of this history of simply not ever using that power, of not wanting to do it, of not following it through. We also now have an incredibly divided Congress who in many ways doesn't even agree on what color the sky is anymore, much less how it is we should handle malfeasance, even if it's criminal malfeasance.
Right.
And historically, there's been this dance between Congress and the federal courts generally, including the Supreme Court specifically. And at certain times in American history, when the court has been going in the wrong direction or has been perceived as behaving in an illegitimate fashion, Congress has intervened, sometimes quite strongly. If we look at the court building that the Republican Party engineered in the wake of the Civil War, they transformed the federal courts. They added seats, they added jurisdictions, and they basically rebuilt the federal courts into an institution that would be more in line with what that regime was seeking. But Congress has not shown itself to be able to mobilize or exercise that kind of power with respect to the courts for quite a long time.
I'm glad you bring that up, Professor, because we know that one of the remedies for this very activist conservative court is, according to a lot of Democrats and liberals, is to reform the court in the way that you said, because on the issue, let's say, of abortion and even gun safety, we know the majority of the country supports universal background checks and some reasonable gun safety laws that have not been able to be passed or are now in the Gruen decision have been the New York decision. The New York law about gun safety has been deemed unconstitutional by the Supreme Court, and we know that the majority of Americans support women's right to choose. So are we at another point, like that point after the Civil War, where the Congress or the executive branch needs to step in to reshape the court, because the court is going in a direction that seemingly is opposite from where the majority of Americans are? And Professor Steigerwald, I'll ask you, does the president have any ability to reshape the court absent a majority or supermajority in the Congress?
He has the ability if obviously there's vacancies that open up. So in using, he does not have the ability, for example, through an executive order. What could happen, though, is the size of the court is determined by Congress. It has not changed since the Civil War, but as Julie was alluding to, it in fact actually changed quite a few times in the years following. They made it bigger, they made it smaller, they made it bigger in part because they were trying to put certain people on and keep other people off. So it has not been a static number throughout history. It has expanded. And there are a number of arguments, right, both pro and con as to why that might happen, but that is fully in Congress's purview. The other place that that Congress does have power, if it wanted to exercise it, is over the court's appellate jurisdiction. What cases is the Supreme Court allowed to hear? And Congress is able to say, no, the courts can't hear cases about this particular topic. Now, again, they don't do that very frequently. They're much more likely to do it with lower courts, but they could if they wanted to. And that would take simply a majority, not a supermajority, though there would be the you have the issue of the filibuster, but relatively, right, structurally speaking, it's a majority.
So, Professor, it seems like there's not, Professor Novkov, we don't have a lot of options here, particularly when you look at the concurring opinion by Thomas in the Dobbs decision, suggesting giving an invitation for red states to challenge laws around gay marriages, contraception. He didn't mention interracial marriages, but following the reasoning used in his concurring opinion, not a far leap to get to interracial marriages as well. What's going to stop Republican attorney generals and other activists from trying to maneuver to get those cases before this 6-3 majority, with the hopes that they will turn back, the clock on things like gay marriages and perhaps even interracial marriages?
Absolutely nothing. I expect that we will see attempts to get those kinds of cases moving forward in the near future. And as we began this discussion, we noted that we need to look beyond the Supreme Court, because some of these cases could go forward in the lower federal courts and create enormous damage in jurisdictions before they reach the U.S. Supreme Court for resolution in either direction. And we have judges on the district courts and on the circuit courts who have shown that they are willing to take these very extreme positions that are destructive of judicial institutions.
Yeah, and Dr. Steigerwald, very disturbing case coming before this court next year around state courts' ability to intervene as it relates to federal elections and giving state legislators a tremendous amount of power, the kind of power that we saw Republicans trying to exercise in the 2020 election, basically throwing out the votes of people and, instituting their own will and determination about who should be electors from their states and basically who those electors should vote for. What are you expecting to happen in that case once it makes its way to the Supreme Court next year?
That is an excellent question. So there have been some justices who so far have suggested that this theory of the independent state legislature, that they are the ones who get to make these determinations. And so that means state courts are not able to interject, might come in there. Now, this puts at tension, actually, a case that was decided not long ago where, written by Chief Justice Roberts, the decision of the court was that federal courts were restricted in the degree to which they could interject. But part of the decision was also laying out that because this was properly the province of the state courts. So this would, of course, be going into that. And so what is sort of the irony here is that with many of these other cases, however, right, for example, dealing with reproductive rights, et cetera, where we're now going to see these cases turn to is actually the state courts. Many state constitutions have much stronger protections, if not an explicit right to privacy written into them. And so we're going to see a lot of things shifting to the state courts while we're also at the same time having this fight over where can we properly go as individuals, as voters, as concerned public to address these issues when we think that there might be a conflict with the Constitution? Well,
and one of the other issues is the fact that not only have Republicans stacked these federal courts, Dr. Novkov, is they've also stacked these Supreme Courts in states. So a lot of these decisions about, say, the state legislators' ability to determine elections, if they are the realm or the jurisdiction of state courts, those state courts have also seen a surge in the number of conservatives, and some would say even extremists, that sit on those state courts. So what does that mean for the will of the people when you have the majority of people who are seemingly going in an opposite direction from some of these judges?
Well, it is an alarming scenario. I mean, there are certainly state courts where you see judges continuing to do the kinds of things that we would expect judges to do. Perhaps they're more conservative than the median state Supreme Court justice in New York or California, but they're still going to they're going to hold on to their judicial power. But it becomes alarming if you see state Supreme Courts collaborating with anti-democratic forces and seeking to support the ways that some states are trying to undercut democracy and undercut voting rights. It again underlines the need for strong federal action. And I'm afraid that asking Congress to do this work may not be enough. My fear is that the only way that we're going to get out of the mess that we're in is through constitutional amendment.
And how difficult is that, Professor Steigerwald? Thinking about a constitutional amendment, I thought you said earlier that that's near impossible.
It is. I mean, it's possible. It's happened a few times throughout history, but it's terrifically difficult. It requires, right, supermajorities in Congress and then ratification from the states, or it can start in the states with state conventions. But again, right, for example, the last attempt was the Equal Rights Amendment. And even though they extended the period of time for states to be able to ratify it, they fell short. And so that is why that is not in the Constitution. So it's a very difficult process, and particularly right now where we are in this period of intense polarization, that is difficult to explain and to really wrap your heads around the degree to which each side sort of sees each other as the enemy, as opposed to a fellow American who might have differing views. It's hard to also come up with what would be something that enough people could agree on to be able to get this measure through Congress as well as the appropriate number of states.
And just finally, it's been in the news recently, this kind of battle that Biden is having with Mitch McConnell over this appointment of this young pro-lifer Federalist Society judge, Chat Meredith, I guess, who apparently there was some leak that the Biden administration was horse trading with Mitch McConnell to get this young judge appointed to a federal bench in Kentucky. And in exchange, Mitch McConnell would stop obstructing two liberal U.S. attorneys who the Biden administration wanted to be appointed in Kentucky. Help us understand, why would the Biden administration feel the need, and this is Andrew Bashar, who's the governor of Kentucky, was livid when this information got out, given that the Senate is, 50, a slim majority for Dems in the Senate, why would there be a need to horse trade with McConnell over a judge like this when the Democrats have the authority to get appointments?
The biggest
authority, but the numbers, I guess I should say.
Two reasons. Number one, most people don't pay attention to what is going on for judges. And so they're a very convenient bargaining tool. The second reason is because if they can get McConnell on board to the degree for which they will not, for example, have to file cloture, have to go through that period, it speeds up the time. The problem is right now with that 50-50 is they're having with every single nomination to waste a lot of floor time in order to actually get them confirmed, floor time that they could be spending on other things like legislation, right? Such as if they wanted to try to take up the bill from the House that has to do with expanding the access to reproductive rights, other things that they might want to be doing.
Yeah, I want to add to the conversation now Dr. Mustafa Ali. He's an environmental justice activist and vice president at the National Wildlife Federation, because we've talked a lot about guns, we've talked about abortion rights, but one of the big decisions coming out of the Supreme Court before it ended its term has to do with climate change. Welcome, Dr. Ali. What was your reaction when you learned that the court in this West Virginia versus the EPA decision basically said the EPA didn't have the power to regulate, emissions from power plants, basically handing over a win to the coal industry?
Yeah. I was disappointed. I wasn't surprised, but I was most definitely disappointed because I understood the human health impacts from the decision that they made. We often forget in our analysis of how this is actually affect aunties and uncles and babies and moms and dads. And this, is going to be deadly for many communities, especially our most vulnerable communities. And when I look at the Supreme Court, I often ask the question, did they do an environmental justice analysis? Because if they had, they would have known that over 200,000 people die prematurely from air pollution every year in our country. So how do you restrict EPA's ability to regulate carbon? And the reason is that when you burn coal, you're not just burning carbon into the atmosphere, but you're also dealing with sulfur dioxide, nitrogen oxides, mercury, particulate matters. All of these things contribute to heart disease and strokes and all these other types of things. So that's why I was so disappointed.
Yeah, and Professor Novakov, help us understand again the reasoning. Is this originalist interpretation that the court used to get to this decision, restricting the ability of the EPA to regulate these companies?
Well, perhaps this is a depressing take, but this was not even the worst version of the decision that many court scholars were anticipating. Justice Roberts held on to this one himself. He did not have it hijacked by the far right wing of the court. We need to keep in mind that at this point, the middle of the court is Chief Justice Roberts and Justice Kavanaugh. And what Justice Roberts ruled is that anytime you have a major rule, you have to go back and look at the statute, and you have to show how the statute would narrowly authorize that kind of major rule change. And in this case, he found that that authorization was not there. But he did not take the opportunity to basically say that Congress has to authorize every single thing that the EPA can do. And once again, you have this kind of cynical political outcome that, well, if Congress wants to take action on climate change and authorize the EPA to take serious action on climate change, Congress is free to do so. We have put no barriers in the way of Congress exercising that power, all while knowing with the political gridlock in Congress, that's extremely difficult to imagine.
And so, Dr. Ali, you are an activist, and not just obviously around climate change, but other issues of related to social justice. What is the activist community thinking about in this moment as it relates to this court? Because we've heard both of the professors say that impeachment of any of these justices seems completely unlikely. Expanding the court, which is one form of reform, would again take congressional action, which appears to be completely unlikely given the makeup of our Congress and our Senate. So where does that leave activists who are worried about climate change, who are worried about women's rights to choose, who are worried about, common sense gun safety laws? Where does that leave the activist community?
Well, the activist community is going to utilize this moment to actually push to make sure that more folks are registered to vote and to make sure they have everything that they need so that that is not impeded. They're also being much more focused now on judges, both on the local and the county, the state, and the federal level. Because we know that Republican brothers and sisters have been laser focused for the last 30 years on that. So now individuals are also understanding, and they are also going much more deeply into those folks who might be running for those positions to really understand their platform and where they stand. So folks are understanding that they have power. My grandmother says you have power unless you give it away. Folks are going to utilize that power to actually push to structurally make sure we have what we need in place.
And that's a great point, Dr. Ali and Professor Steigerwald. Why has the Democrats, if you're a political scientist, you've studied this, why have the Democrats not been more focused on appointment of judges and certain types of judges with certain ideologies at each branch, from each level of government, from state court judges to Supreme Court judges, and then on the federal bench? It just doesn't seem like there's been the kind of concerted effort on the left as it's been on the right.
So there actually has been, and the irony is that it was really the first groups that existed, interest groups that were really advocating for sort of paying attention to lower court judges and who was being appointed and who was being vetted, were actually liberal groups that formed during the Reagan administration. And were really the first ones to that brought attention to it and started really suggesting there needed to be more vetting, that it should not simply be that they would be easily taken through, and given attention to that. Some of what has happened is that there is a strong case to be made that recent Senate majority leaders, particularly Republican Senate majority leaders, have been much more willing to exercise their power of what we call negative agenda control than we've seen in past times, not allowing judges to even come to a vote. And in fact, simply not bringing them up, that they sat there for not only 200 or 300 days, but some of them sat for 4,000 days through multiple administrations. And the problem was there was not much that could be done to try to push them through. We would see efforts, we would see negotiations happening. This is, you might remember, the Gang of 8, the Gang of 14, the Gang of 7. A lot of them were really about negotiating, getting certain judges through and trying to get that process started again. But it's very difficult. And it's very difficult, particularly so, again, Mitch McConnell was terrifically successful in shutting down the confirmation process during the Obama administration. and simply not allowing it to move. And some of the problem is that as much as the activists were out trying to pull attention to this, for most people, it just isn't something that they really understand or are able to pinpoint, right? The number of people who don't really get what happened with Merrick Garland, or perhaps have never heard the name, is really high. And that's part of the sort of issue that comes on this, is it means that if you've got the concerted effort, if you're using those parliamentary procedures, you can really grind it to a halt and control the process.
So, Dr. Ali, how are you in the environmental community getting activists to understand the impact of this decision, this West Virginia decision, and this, court saying, well, Congress can, decide what it's going to regulate, knowing that Congress is at this stalemate? How are you getting people to understand on the ground level the importance of voting? I'm thinking about the sample ballot. We just had our primaries in California. And the ballot was, 20, 30 pages. There were a long list of judges. Most people have never heard of them. They give you very short, brief descriptions of who these judges are. There's sample ballots by different, political groups that try to help people, but the majority of people just skip. They vote for the candidates that they know, the mayor, maybe the governor, maybe their senator, but they don't even bother to check a box. And so a small minority of people in many jurisdictions are electing those judges. So how are you getting this message out to people that this is important and you can't just skip those judgeships? You got to vote.
Yeah. Well, folks are taking it to the street. And what I mean by that is that there's an educational set of campaigns that are happening to actually break down for folks where people stand on the issues, why it matters. How does it impact your life? Because if you're not sharing with folks how it impacts their life, they're probably less likely to actually get engaged in the process, and to also share with them what the levers of power look like and how we have to reform them to actually make sure it's beneficial for all of the folks in our country instead of some of the folks.
Yeah, that's a really important message. I'll give you the last word, Professor Navkov. Any words of encouragement? This is a kind of grim conversation. It looks like, we know these judges are there for life. We know that Trump essentially flipped the appellate court from a majority Democratic court to now a majority Republican court. I'm thinking about the 2024 elections and all the challenges that we're likely to see if the Republican candidate doesn't win, and all the damage that can be done by the Supreme Court on the rights that we've enjoyed in this country for so long. So give us some words of hope and encouragement.
Dr. Ali is absolutely right. He has the answer. We have to mobilize. We cannot leave it to politics to solve this for us. We can't leave it to national political institutions or even state political institutions. There has to be an enormous upswelling of popular pressure and a demand by the people to take back their democracy and make it ours and make it serve us and protect ourselves and protect our rights.
I love that. Take back our democracy. Absolutely. Well, thanks to all of you for enlightening us on these really important topics and helping us to, get folks to start thinking about, because everybody's voting all over this country. Primaries are happening every day, and we all will be voting in the general election in November. So we all have an opportunity to get educated on our local judges. And again, the folks who we're sending to Congress and to the Senate, who have so much power, particularly that the Senate, in terms of who gets appointed to our federal judiciary. So again, thanks for your insights. And we're going to keep taking it to the streets, as you said, Dr. Ali. Appreciate you this morning. Wow. Well, thank all of my guests. What an interesting show. Again, you may not think a lot about judges, but you got to start thinking about them because they do impact your lives. Everything that we do, every freedom that we enjoy in this country is going to be decided, or has been decided by some policymaker. And it's not just those that are in the Congress and the Senate. The judiciary has tremendous power. And although the current makeup of the court is 6-3, we should not let a day go by without celebrating Ketanji Brown Jackson and her appointment to this U.S. Supreme Court. Over 200 years it took to get a Black woman on this court. Now, she won't shift the power in terms of the liberal conservative numbers, but her voice is so, so important. Her lived experiences, her experience as a public defender, her experience working in corporate America, her experience as a mom, as a philanthropist, as someone who works in her community, all of those experiences will be so critically important. And I have to believe in my heart of hearts that there's going to be a look that only a Black woman can give to a Black man like Clarence Thomas that may soften his heart and may cause him to rethink if he is hell-bent on making our lives miserable, that may cause him to rethink that. So super, super proud and ecstatic about Ketanji Brown Jackson and what she's going to bring to the court, which brings me to my words to live by. And these are by the late Justice Ruth Bader Ginsburg. And Justice Ginsburg said, "People ask me sometimes, when will there be enough women on the court? My answer is, when there are 9. All right, be safe out there. Remember, we're all in this together. And I couldn't agree more with the justice. When there are 9 women. Take care.